I recognize the Honorable Premier.
Madam Speaker, in the absence of the opposition, I wish to bring this budget presentation to a close. But Madam Speaker, if you'll permit me just a few words in the absence of a formal response from the opposition. And I think of what was said at the closing on the adjournment, where the opposition sought to give the impression that we were not giving them an opportunity to prepare for a budget response. Madam Speaker, had the acting leader of the opposition waited, she may have recognized that we were going to have an adjournment until tomorrow at 9 o'clock. It was simply a matter of her waiting. When it comes to talking about bullying, etc., that is not something which we do. But Madam Speaker, just bear with me a moment. And this is for the elucidation of the public. The budget is about the estimates. The estimates, that is the appropriation bill which we're presenting here this week. It is not about the speeches and whatever else is being said. Yes, one can draw inferences from whatever is being said in the so-called very long speech. But Madam Speaker, one of the things which we learn in our parliamentary democracy is that debate is precisely what it says. A presentation is made, and even the debaters from our debating society who compete in the region, they don't get an extra day to prepare their rebuttals from anything which is said. The rebuttals are done immediately, because when people elect their representatives, they expect them to have the intellectual fortitude to make notes and be in a position to debate immediately after. And I wish to draw a couple examples. Back in the day, when the Honorable John Osborne was Chief Minister, we had a meeting at Viewpoint Hotel. He made his budget presentation in the morning. His ministers responded. We broke for lunch. And immediately on resuming the sitting, as leader of the opposition, I contributed to the budget debate. 2 hours. 2 hours. Without having to wait to get my advisors to advise me. We do not elect advisors to this House. We elect representatives who are expected to think for themselves.
Okay, Honorable Premier, it's unfortunate that what happened this morning happened, but let us try and wrap up this section and let us go into the actual debate.
Thank you very much, Madam Speaker. I am seeking to put a perspective on what may be put out there to the public, that we were disenfranchising the opposition. And therefore, I have to make it pellucid that we were not seeking to do anything to stop the opposition from being able to participate. So, Madam Speaker, having said that, I commend the appropriation bill to this honorable House for its second reading.
A motion was moved and seconded. It was seconded yesterday for the appropriation bill 2026 to be read a second time. All those in favor, say aye. Those against, nay. I think the ayes have it. The ayes have it. The bill will be read a second time.
Appropriation Bill 2026.
And now the House will go into committee to consider the bill in further detail. Okay, so we will commence with the Development Fund vote. Vote 12, Office of the Deputy Governor, in the amount of $5,061,100. That should form part of the schedule. Those in favor, say aye. Those against, nay. I think the ayes have it. The ayes have it. Vote 15, Office of the Premier, $261,200. All those in favor that it should form part of the schedule, say aye. Those against, nay. I think the ayes have it. The ayes have it. Vote 17, Cabinet Secretariat, $101,900. All those in favor that it forms part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 18, Department of Communications and Digital Transformation, $438,400. All those in favor, say aye. Those against, nay. I think the ayes have it. The ayes have it. Vote 20, Ministry of Finance and Economic Management, $32,310,400. All those in favor that it form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 30, Ministry of Agriculture, Lands, Housing, Environment, Youth Affairs and Sports, $2,527,900. All those in favor that it forms part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 35, Ministry of Buildings, Utilities, Infrastructure, Labor and Transportation, $50,913,800. All those in favor that it should form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 40, Ministry of Education, $579,500. All those in favor that this amount should form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 45, Ministry of Health and Social Services, $70,428,300. All those in favor that it should form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. And now the total development fund votes, $162,622,500. All those in favor that that amount should form part of the schedule, say aye. All those against, say nay. I think the ayes have it. The ayes have it. Total development fund votes in the amount of $162,622,500 now stand as part of the schedule. Moving on to the supply votes. Vote 5, Police, $10,563,700. All those in favor that it forms part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 7, Legal, $2,089,000. All those in favor that it forms part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Vote 8, Magistrates Court, $468,100. All those in favor that it should form part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Vote 9, Supreme Court, $1,442,800. Those in favor that it should form part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Vote 10, Legislature, $1,764,600. All those in favor that this amount should form part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Vote 11, Audit Office, $1,280,900. All those in favor that it form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 12, Office of the Deputy Governor, $39,743,000. All those in favor that it should form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 13, Public Prosecution, $1,036,500. All those in favor that it forms part of the schedule, say aye. Those against, say nay. The ayes have it. Vote 14, Financial Intelligence Unit, $1,079,700. All those in favor that it form part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Office of the Premier, vote 15, $15,951,900. All those in favor that it form part of the schedule, say aye. And those against, say nay. The ayes have it. Vote 17, Cabinet Secretariat, $1,069,100. All those in favor that it forms part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Vote 18, Department of Communications and Digital Transformation, $2,865,700. All those in favor that it form part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Vote 20, Ministry of Finance and Economic Management, $42,890,600. All those in favor that it form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 30, Ministry of Agriculture, Lands, Housing, Environment, Youth Affairs and Sports, $9,297,200. All those in favor that it form part of the schedule, say aye. And those against, say nay. I think the ayes have it. The ayes have it. Vote 35, Ministry of Buildings, Utilities, Infrastructure, Labor and Transportation, $14,569,000. All those in favor that it should form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 40, Ministry of Education, $10,824,200. All those in favor that it should form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Vote 45, Ministry of Health and Social Services, $26,387,900. All those in favor that that amount should form part of the schedule, say aye. Those against, say nay. I think the ayes have it. The ayes have it. And the total supply votes in the amount of $183,323,900 should stand as part of the schedule. All those in favor, say aye. And those against, say nay. I think the ayes have it. The ayes have it. The total supply votes in the amount of $183,323,900 now stand as part of the schedule. And to the summary, where the development fund votes in the amount of $162,622,500, plus the supply votes of $183,323,900, for a grand total of $345,900,000 $946,400 should stand as part of the schedule. All those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. The grand total of $345,946,400 now stand as part of the schedule. And the further question is that the schedule should stand as part of the bill. All those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. The schedule now stands as part of the bill. Clauses 1 to 6. The question is that clauses 1 to 6 should stand as part of the bill. All those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Clauses 1 to 6 now stand as part of the bill. Enacting clause and long title. Question is that the enacting clause and long title should stand as part of the bill. All those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. The enacting clause and long title now stand as part of the bill. And the final question is that the bill be reported to the Assembly. All those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. The bill will now be reported to the Assembly. The Assembly will now resume its sitting. I recognize the Honourable Minister of Finance.
Thank you very much, Madam Speaker. Madam Speaker, I'm pleased to advise this Honourable House that a bill shortly entitled the Appropriation Bill 2026 has passed to the committee stage of this Honourable House without any amendments. May I also, Madam Speaker, ask for a suspension of the appropriate standing order to facilitate a third reading of the bill. Thank you very much, Madam Speaker.
Madam Speaker, I stand to second the motion for the suspension of the requisite standing order for a third reading of the bill.
It has been moved and seconded that Standing Order number 53 be suspended to facilitate the third reading of the Appropriation Bill 2026. All those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. Standing Order 53 has been duly suspended. And did you? No, so now for the third reading. It has been moved that the bill, shortly entitled Appropriation Bill 2026, be read a third time and passed in this Honourable House. Those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. The Appropriation Bill 2026 will now be read a third time.
Appropriation Bill 2026.
The Appropriation Bill 2026 has been read a third time and is accordingly passed. I recognize the Honourable Minister of Finance.
Thank you very much, Madam Speaker. Madam Speaker, I rise to move a motion for the second reading of the bill shortly entitled Payment Systems and Services Bill 2026. But, Madam Speaker, in presenting that bill, I will just go through some of the clauses. Clause 3 provides that the purpose of the bill is to establish a legal framework to enable a payment system that is safe, efficient, and resilient, inclusive and competitive through the management of risk, the maintenance of financial stability, and the protection of the interests of consumers. This aspect, Madam Speaker, is critically important because you're looking at maintaining the stability of the financial system and also at the same time protecting the interest of the consumers. Clause 4 sets out the functions of the central bank. And I read, the central bank is empowered to monitor and oversee the payment system, promote financial inclusion and financial innovation, protect consumers, and ancillary to these powers, continually modernize the payment system through new policies, establishing standards and procedures, and monitor and oversee the clearing and settlement system. Clause 5 empowers the central bank to support the operations and the participants of a payment system, including ownership and participation. Clause 6 empowers the central bank to establish, own, operate, or participate in the ownership of a system, act as a central counterparty, open and hold accounts for an operator or a participant, and hold securities for clearing and settlement transfers. So, Madam Speaker, this clause is looking at creating a system that will ensure that there's fluidity in the system and that there's transparency in the movement of money across the ECCU. Clause 7 empowers the central bank to direct a payment service provider to enter into an agreement with the operator of the payment system to achieve interoperability of the payment account with the payment system. In other words, you can't have an operator just operating on their own. You can't just have people coming into the system and saying, oh, I want to operate a system, and do it without some sort of transparency and some sort of control. Clause 8 authorizes the central bank to cooperate with other public authorities engaged in the regulation and supervision of financial institutions and other entities directly or indirectly involved in payment services and their operation. Again, a means of control. Clause 9 establishes the Eastern Caribbean Payments Council for the purposes of advising the central bank on the oversight of the payment system and provides for its composition. So this is now ensuring that the central bank just does not operate of its own volition, but there would be an oversight committee and an oversight system which will ensure that there's community participation. And that is the formation of the Eastern Caribbean Payment Council. Clause 11 requires that a member who has a pecuniary, and that is a financial interest, or other interest in a matter before the council must declare his or her own interest to the council and for related matters. In other words, Madam Speaker, we don't want to have persons who are looking out for their own self-interest on the council. We want to ensure that there's a level of transparency which the public will be willing to accept. Clause 14 establishes four classes of licenses, and allows the central bank, after consultation with the minister, to specify others. And minister here means the minister with responsibility for finance from time to time. Clause 15 provides for the application for a license to be made to the central bank within the prescribed form and fee. There will be a fee for the establishment of these money transfer services. Clause 17 requires that the central bank registers the name of the licensee, issue the license, and publish the issuance. So one cannot ask for a license and have it done in the cover of darkness or under wraps. The public must know through the publication that these licenses have been applied for, who has applied for the license, and also where they're operating from. And it also prohibits the transfer of the license from one operator to the next. Clause 19 authorizes the central bank to place conditions on a license based in part on risk and on risk basis assessment. The central bank considers necessary and may also amend any conditions of a license by way of an alternation, substitution, addition, or other modification. Clause 23 sets out that the central bank may decide to suspend or revoke a license issued under specified conditions. The central bank is required to notify the licensee, but notwithstanding this provision, the central bank may suspend or revoke a license without notice if it is in the public interest or to protect the interests of participants and consumers. So clause 23 here looks at how does the central bank deal with the protection of the consumers. Clause 36 provides that a licensee or licensed financial institution, and licensed financial institution here refers to commercial banks, or a credit union, is required to promptly notify the central bank in the event of certain occurrences such as criminal proceedings, insolvency, and disciplinary action, and must give prior notice to the central bank of any material changes to products and services for which it is licensed. So a license is granted to provide a particular service, and if you want to change that service, then you have to go back to the central bank to have your license amended. Clause 29 provides that the central bank may monitor emerging and innovative payment systems and technologies, receive applications for the innovative payment system and technology to be reviewed, tested, and monitored. And the central bank may use and issue guidelines prescribing the mechanisms to review, test, and monitor an application for the provision of an innovative payment system or technology. And Madam Speaker, this one speaks especially to a new system which has been developed by some young Montserratian techies. And I do commend this one, and I'm absolutely certain that they would be happy for this particular clause and that their business will succeed as they look at developing a local payment system which is proven and tested by the British authorities and can in fact be converted to the Caribbean, but to Montserrat firstly. Clause 30 sets out that a license and a licensee and participant are required to provide any information required by the central bank in relation to its business or the business of its affiliates, make staff available for interviews with the central bank or any person appointed by the central bank where necessary, and the section creates an offense for failure to employ or to comply if false or misleading information is provided. Again here, Madam Speaker, if you're into the money business, you must be willing to follow the rules and to provide information which is true and accurate. That is the basis of banking and money transfers. Clause 32 sets out that the central bank may conduct an audit or commission an independent auditor to conduct an audit of an operator, participant, or payment service provider annually or when issues arise that are of regulatory concern. Again, Madam Speaker, when we're looking at moving money around, we want to ensure that the institutions that are performing this function are auditable and, in fact, are willing to open their books for auditing purposes. In other words, we can't expect shenanigans to take place in our financial system. Of course, we have to look at confidentiality, and that is included. But Clause 35 prohibits a person from carrying out activities as an agent of a payment service provider prior to being authorized by the central bank, and where a payment service provider intends to provide a payment service to a customer through an agent, the payment service provider is required to make an application submitting the name and address of the proposed agent, internal control mechanisms to be compliant with the Proceeds of Crime Act, and identify of the agent's directors. The section also creates an offense for the unauthorized use of an agent. Again, Madam Speaker, one can have a license and then allow anyone to operate under their license. This clause ensures that any agent or subagent must be authorized and given permission by the central bank. Clause 37 sets out requirements for compliance with anti-money laundering and combating the financing of terrorism and proliferation of financing. Under this section, a licensee or third-party agent is required to comply with the requirements of the Proceeds of Crime Act and any guidelines, directives, or rules issued or adopted by the central bank or any other relevant authority. And again, Madam Speaker, all of us in the Caribbean are controlled by FATF and other agencies where they seek to ensure that we are indeed complying with international regulations. Clause 41 requires an operator to establish clear written rules for the governance, management, and operations of the system, which the operator is licensed to operate. The rules are subject to review and recommendations of the central bank prior to the start of the operations of a system. Again, Madam Speaker, you're looking at putting in place controls to ensure that people's money is safe. Clause 43 mandates that on access to payment, clearing and settlement systems must not inhibit access to more than is necessary to safeguard against specific risks such as settlement risk, operational risk, and business risk, and to protect the financial and operational stability of the system. Clause 44 sets out rules on transparency of fees, terms, and conditions. Under this section, the central bank may establish rules to ensure transparency of conditions including fees and information requirements for payment services, and the central bank is required to publish the rules on its website. And indeed, Madam Speaker, rules and fees are included in that publication. So you cannot just walk into an agency and they look at you and say, okay, you have money, so therefore we're going to charge you a different fee to my friend the fittest man on the other side there. Clause 46 provides for disclosure of terms and conditions. This section requires that a licensee, a participant, or an agent discloses specific terms and conditions to a customer of a payment service involving the customer's account at the time of the customer's contracts for the payment service. In addition, a licensee, participant, or agent is required to notify a consumer in writing at least 21 days prior to the effective date of any change in any term or condition of the consumers that is required to be disclosed. And this point is very, very important as well. Clause 47 provides for complaints under this section. A customer of a licensee, participant, or an agent who is aggrieved by any act or omission of a licensee, participant, or an agent may make a complaint in writing to the licensee, participant, or agent for remedial action. Failing any response, the aggrieved party may appeal to the central bank. And we have seen cases, Madam Speaker, where people go into money transfer services, they have issues and problems, but there's no way they can complain or get satisfaction. And this clause makes and ensures that the customers have a means of addressing their grievances. Clause 50 provides for a netting engagement, which shall be valid and enforceable, and an operator or participant in the system shall do what is permitted or required under the netting arrangement in order to give effect to the netting arrangements. Clause 52 provides that the rights and remedies of a licensee, participant, clearinghouse, central counterparty, or any third party in the system and the central bank with respect to collateral granted to it as security for a payment of the performance of an obligation incurred in a system not be affected by insolvency or bankruptcy proceedings or any other law written in similar purpose and effect. So in other words, Madam Speaker, an agent just can't declare that they're insolvent and they're bankrupt, and your money goes to naught. Clause 53 requires a participant of a system to immediately notify the operator, and the operator shall immediately notify the other participants of the system where the participant is insolvent or is likely to become insolvent, has become or is likely to become unable to meet any or all of its obligations, or has suspended payments or compounded with its creditors. This section sets out the same requirements for operators of a system. And again, this is to protect the consumers. So this is not just about central bank oversight. We're looking as well as protecting the clients who use those services. Clause 55 sets out that a licensee or participant, against whom a winding up application or scheme of administration has been lodged, or a decision for voluntary dissolution is made, shall be prohibited from operating or participating in any system until such application or scheme is disposed of or finally determined. So, Madam Speaker, I can't be operating a payment system. I go bankrupt, and then I change my name or the name of my business to something else, and then I can go across the road and open up another shop. And this clause takes care of that. Clause 59 sets out the choice of law in the event of insolvency of a foreign participant. Foreign participant here means a participant whose base of origin by incorporation is outside the CARICOM member states. Within CARICOM, we have a means of doing our own business for ourselves, but we have to protect against companies that are operating outside of the ambit of CARICOM and the OECS. Clause 60 empowers the central bank in relation to a licensee, a participant, its directors or officers, to give direction, issue a warning, conclude a written agreement, or give an order where the central bank is satisfied that a director, manager, officer, or an individual who manages and controls the licensee or participant is not fit and proper person. The central bank must specify the activity, behavior, or practice that must be terminated or remedied, and the date by which it should be terminated or remedied. And I think that's clear, Madam Speaker. We don't want to have persons who are of uncertain character to be operating financial transactions in our financial payment system. Clause 62 stipulates the arbitration by law. Clause 63 requires that a licensee or participating processes personal data through a system in a manner that facilitates the prevention, detection, and investigation of payment fraud, and in accordance with any law governing data protection. Again, Madam Speaker, we don't operate only in Montserrat, we operate across the entire world. So whatever we do here, and we do it badly, will affect our reputational risk across the world. And again, given that we are aid funded, we also have to look at our relationship with our paymasters. Clause 66 provides that an electronic funds transfer and a record of an electronic funds transfer is enforceable and has the evidentiary value in accordance with the law relating to electronic funds transfer, and empowers the central bank to make applicable rules and guidelines. This is simply meaning, Madam Speaker, that nowadays we can go on our phones, using our tablets or whatever electronic versions we have, to be able to make transfers without going into the institution. And this clause gives protection to individuals using electronic transfer arrangements. And it also sets out the rules and guidelines for the purpose of giving effect to international standards as set out by the Act. Clause 70 provides that any act, matter, or thing done by an officer or person employed by the central bank or by any other person in the exercise or performance or purported exercise or performance in good faith of any power or function under this Act shall not give rise to any action, claim, liability, suit, or demand against the officer or persons concerned. So this is a protection against the persons who are monitoring the system, and they're doing it in good faith. Clause 72 allows a payment and settlement system or operator in existence before the coming into force of this legislation to continue to operate subject to the provisions of this legislation. So if I'm already doing business in the payment system, I will be grandfathered into this, but I also have to abide by all of the rules and regulation of this legislation. And finally, Madam Speaker, this is a regional legislation of the ECCU member states. All of us will be enacting this particular bill so that we have uniformity and conformity within the ECCU area. May it please you, Madam Speaker, I do request the second reading of this bill.
Do we have a seconder? I recognize the Honorable Deputy Premier.
Madam Speaker, I rise to support the second reading of the Payment System and Services Bill.
Are you reserving your presentation, or someone else? Do you?
Madam Speaker,
You
I
want to
think
go ahead now?
I can do it now.
Okay.
Madam Speaker, I'll be very brief. The Honorable Premier Minister of Finance has given us a comprehensive overview of the Payment System and Services Bill. And Madam Speaker, I am pleased to say that with the proliferation of institutions and businesses in this area requires the robust control that I see established by this bill. I see protection, I see regulation of financial institutions, I see oversight, procedure, and combating crime and safeguarding our consumers and our reputation. Madam Speaker, we know that with the challenges that we have with our own banking system, it is good for Montserrat to have such institutions. I'm also heartened to learn that there are local Montserratians who will be engaging in this type of business. I am also very pleased to see the integrity, transparency, and for the public as well. And I must also record my satisfaction that invading the privacy of businesses will not be taken willy-nilly, but requires a high court search warrant. It shows the seriousness with which this bill considers the operations of such institution. I also want to applaud Clause 32 of the bill, where audits will be conducted, and I believe not only protect the consumers at first glance, Madam Speaker, but protects against liquidation later, since audits can be conducted given the health status of the companies or businesses which are involved in this. Again, confidentiality is protected, and also 7 years before any documentation can be destroyed. Every system, Madam Speaker, must be fair, and the appeal process and complaints process outlined in Clause 47 gives me the confidence to support this bill. I know that it is one which will be supported throughout the ECCU. However, Madam Speaker, as a representative of the people, it behoves me to still examine what is happening. Protection of personal data, again, I welcome that. And again, our reputation, because if any person can come in, and as Premier explained again, just change names, we will be protecting our people. So, Madam Speaker, it gives me confidence to stand in support of this bill and its operation in our jurisdiction.
House is open for further debate. Any other? So if there's no other, Honorable Premier, would you like to wrap up? Give a response, please. I recognize the Honorable Minister of Finance.
Thank you very much, Madam Speaker. Madam Speaker, I do commend this bill for its second reading.
It has been moved and seconded that the bill, Payment System and Services Bill 2026, be read a second time. All those in favor, say aye. Those against, say nay. Think the ayes have it. The ayes have it. The bill will be read a second time.
Payment System and Service Bill 2026.
The Assembly will now go into committee to consider the bill in detail. I recognize the Honorable Minister of Finance.
Thank you very much, Madam Speaker. Madam Speaker, I am pleased to report to this Honourable House that the bill shortly entitled Payment System and Services Bill 2026 has passed through the committee stage of this Honourable House without amendment, and I do commend it for its third reading.
Someone second the motion, please. Recognize the Honorable Deputy Premier.
Madam Speaker, I rise to second the motion. Thank you.
It has been moved and seconded that the bill shortly entitled Payment Systems and Services Bill 2026, as amended, should be read a third time and passed. All those in favor, say aye. Those against, say nay. I think the ayes have it. The ayes have it. The bill, as amended, will now be read a third time.
Payment System and Service Bill 2026.
The Payment Systems and Service Bill 2026 has been read a third time and is accordingly passed. I recognize the Honorable Minister of Finance.
Madam Speaker, I rise to move a motion for the second reading of the Eastern Caribbean Deposit Insurance Corporation Agreement Bill 2026. Madam Speaker, this is a bill, and again, it's part of regional legislation. This bill has been around for some time. It comprises 7 parts and 45 articles. But what is critically important is that the purpose of this Deposit Insurance Corporation Agreement Bill is to implement a deposit insurance system in the Eastern Caribbean Currency Union as part of a comprehensive financial sector safety net to protect small, vulnerable depositors, promote sound financial stability of the financial system, and to strengthen consumer confidence and protection. If I may read that again. It is to implement a deposit insurance system as part of a comprehensive financial sector safety net to protect small, vulnerable depositors, promote sound financial stability of the financial system, and to strengthen consumer confidence and participation. Madam Speaker, I had the misfortune of living in Barbados when a particular institution, a banking licensed financial institution, went under. And I recall at least one school teacher who was so prudent in relation to her funds that she ate sandwiches every day and saved her money diligently. Unfortunately, when the bank went under and she went to the bank to collect her money, they offered her 5 cents to the dollar. She was unable to speak after that, and she was sent immediately to a psychiatric institution. I recall as well when the Bank of Montserrat was undergoing insolvency. I was the chief minister at the time, and I saw that this system that happened in Barbados would never happen here. So we've been working since then, back in the 90s, to ensure that we were in a position that if a bank went insolvent, that there would be some insurance to protect the small depositors. And this Eastern Caribbean Deposit Insurance Corporation Agreement is giving effect to that. The protection of our small depositors so that in the event of insolvency of a financial institution, that they would get back part, if not all, of their deposits. Part 1 of the agreement, establishment and governance of the corporation, contains Article 3 to 13. Under Article 3, matters relating to the establishment of the Eastern Caribbean Deposit Insurance Corporation, hereinafter referred to as the corporation, are provided for in Article 4 and provides for the establishment of a principal office or branch or the appointment of a representative of the corporation and the according of correlating immunities and privileges. Article 5 outlines the principal objectives of the corporation, including the establishment of a deposit insurance system to provide insurance against the loss or part or all of deposits. The function and powers of the corporation are set out in Article 6. These functions include the provision of insurance against the loss of deposits, the management and administration of the fund, and the imposition of penalties for breach of the agreement. In undertaking its functions, the corporation has powers, among others, to assess and levy premiums and fees from policyholders, makes compensation payments in respect of insured deposits to depositors or to another policyholder, and make inquiries to a supervisor of a policyholder concerning the conduct of the affairs of the policyholder. Matters concerning the constitution and tenure of the board of directors, hereinafter referred to as the board, are set out under Article 7. The board determines its own proceedings, save with respect to the circumstances enumerated under Article 8. By Article 9, a director is required to disclose and abstain from deliberating on any matter in relation to any interest that may conflict with the exercise of his or her duties on the board. In other words, Madam Speaker, a board member should not be conflicted. And if they are conflicted and have not disclosed it, there is punishment included in the bill for so doing. Article 11 enables a director who is a representative from a ministry of finance of a member state to designate an alternate to attend a meeting of the board. The remuneration and compensation of the directors are determined by the board under Article 12. The board is required to appoint a manager under Article 13 who is responsible for the day-to-day management of the corporation. So although this is a ECCU bill, regional bill, it's not managed under the auspices of the central bank, but in fact through a corporation managed by a board of directors. The Deposit Insurance Fund is established under Article 14. The sources of the fund include premiums, levies, and other fees paid by policyholders, contributions made by the central banks, and amounts borrowed by the corporation for the fund. So you're not just dealing with the central bank or government providing the equity for this corporation. Depositors will, in fact, have to pay a minimal fee in order to obtain this protection, as is with any other insurance. Article 15, a licensed financial institution is required to hold a deposit insurance policy and to pay any premium assessed in relation to it. Article 16 provides that the deposit insurance coverage with respect to each deposit is 50,000 Eastern Caribbean dollars. Article 15, a licensed financial institution is required to hold a deposit insurance policy and to pay any premium assessed in relation to it. And Article 16 provides the deposit insurance coverage with respect to each deposit is 50,000 Eastern Caribbean dollars. Madam Speaker, some of us don't have that much money in the bank, but that's the level of coverage which is being assessed by this corporation. For those like the Honorable Hector, who may have much more than that, that does not include them beyond $50,000. Maybe she doesn't have it now, but I expect she'll have it eventually. To God be the glory. The types of accounts that must be covered. That must be insured are outlined in Article 17, such as savings account, checking accounts, travelers' checks, and term deposits. So it covers the spectrum of accounts. Article 18 sets out the assessment and payment of premiums, including differential premiums. The corporation may cancel the policy in the circumstances enumerated under Article 19, including where the license of the policyholder to do business has been revoked or the policyholder has not paid the premium 45 days after the due date. Each policyholder has to pay a minimum premium. The corporation rights to subrogation is specified under Article 21, and Article 22 sets out the time limit for making a claim for a compensation payment. Article 23 outlines the persons who are eligible and ineligible to receive a compensation payment. Sorry, Mrs. Dorset Hector. Notably, the corporation shall not make a compensation payment to a depositor where, on consultation with the supervisor, the corporation reasonably believes that a director, officer, or significant shareholder is a depositor and has been party to or has benefited from the circumstances which gave rise to the closure or failure of the policyholder. So in other words, I can't be a director, cause the institution to go insolvent, and then claim a benefit. Once you're a director, you need to understand that you're also personally liable for what happens within the institution. You can't claim monies. Article 24 provides that joint deposit owners are entitled in equal share to a compensation payment up to the maximum of the insured limit. The insured limit of $50,000. So myself and Dorset Hector have a joint account. You're going to set up one with me. She'll put in most of the money. We have a joint account, and we need to make a claim. She will get $25,000, and I will get $25,000. And I'm not giving her back any because she had put in more. Part 3 of the agreement with the finances of the corporation. This part contains Article 26 to 28. Under Article 26, the authorized share capital of the corporation is set at $1.5 million, to which the central bank is the sole shareholder. Article 27 enables the corporation to increase its authorized share capital where necessary for its proper functioning. Matters related to the finances and audit of the corporation are detailed in Article 28, including the financial year, appointment of an external auditor, and presentation of the audit report to the board. So, Madam Speaker, although you are looking at a share capital of $1.5 million, it does not mean that that is the total sum available or which will become available for compensation in the event of problems. Part 4 contains Article 29 to 32. Article 29 empowers the corporation to employ fixed and temporary staff. Under Article 30, the corporation is entitled to receive specified documents from a supervisor, including on-site examination reports on policyholders. The corporation may also submit to a supervisor or specified entity information likely to enhance the financial soundness of a policyholder or financial stability within the currency unit. Under Article 31, financial institutions are required to cooperate with the corporation, and Article 32 contains confidentiality provisions with respect to a director, officer, or employee of the corporation. When we're dealing with people's money, Madam Speaker, confidentiality is paramount. Immunities, privilege, and dispute resolution. Article 32 to 40. Under Article 33, each member state is required to accord certain status, immunities, and privileges to the corporation. The corporation enjoys immunity from judicial process, save in specified circumstances under Article 34. The assets of the corporation are immune from all forms of search and seizure, and its archives are inviolable under Article 35. By Article 36, the assets of the corporation are made free from restrictions. Article 37 provides that the official communication of the corporation is privileged. Under Article 38, a director, an officer, or an employee of the corporation is immune from legal process and entitled to indemnification for good faith acts and omissions. Article 39 provides that the corporation, its assets, operations, transactions, and income are exempted from tax, save and except public utility services, salaries and emoluments paid by the corporation to the directors, officers, agents, employees, and representatives of the corporation are also exempt from tax. And this, again, is because of the regional nature of this corporation. Article 40 provides for the settlement of disputes between the corporation and the government of a member state by negotiation in the first instance and by a tribunal of arbitrators if the dispute is not resolved. Article 41 to 45, financial provisions. According to Article 41, the agreement comes into force on the deposit of the instrument of ratification by the government of a member state. Under Article 42, the Director General of the Organization of Eastern Caribbean States is identified as the depository for the purposes of this agreement. By Article 43, the government of each member state is required to take all steps necessary, whether legislative, executive, or administration, for the implementation of the agreement. Article 44 provides that the board may propose amendment to the agreement to the Monetary Council. An amendment becomes effective when it is agreed by all governments of the member states. All. Article 45 states that a member state cannot make a reservation in regard to any provision of this agreement. So, Madam Speaker, in the presentation of this bill to this Honourable House, if the House finds it in their wisdom to approve it, it means that shortly afterwards, Montserrat will go through and provide the instruments of ratification so that this agreement comes into effect immediately and that our depositors will have their deposit insurance scheme in place. If it pleases you, Madam Speaker, I've already asked to move a motion for the second reading.
Can we have a seconder, please? I recognize the Honorable Deputy Premier.
Thank you, Madam Speaker. I stand to support the motion for the second reading of the Eastern Caribbean Deposit Insurance Corporation Agreement Bill 2026.
Okay, the House is now open for debate. I recognize the Honorable Financial Secretary.
Thank you, Madam Speaker. One point of clarification in terms of policyholders. By definition, in the bill, policyholders means financial institution under Article 15. Therefore, only financial institutions will be required by law to pay premiums and fees, and not individual depositors. Thank you, Madam Speaker.
Okay, so the House is now open for debate. Are there any presentations on the bill? If not, Honorable Premier, I recognize the Honorable Deputy Premier.
Madam Speaker, very brief. I want to commend the strength of this act and the bill, and it demonstrates for us the seriousness in which the Eastern Caribbean ECCB is going to protect depositors. Our Honorable Premier would have drawn, Madam Speaker, an example of the dire consequences and impact that can happen to a depositor who puts all that they have into a bank. And Madam Speaker, I know this is not dealing with insurance per se, but we have heard so many stories of what has happened to persons who have put all that they have, expecting that in their old age or later on in their autumn years, and also inheritance for their children, have lost it all. I've also noted that I do not see any dissensions on the signature page of the members to this agreement. It's all signed up, and that is commendable. Recent times we may hear of division here and there, but this is a unifying vote that has been received. And I truly want to commend this bill to the House, and I think I'm of the view that we can do so safely, knowing that our depositors here in Montserrat in the region would be protected. Nothing is infallible, but Madam Speaker, it gives me great confidence to stand here to second this bill and commend it to the House.
I take it there are no more presentations, so Honorable Minister of Finance, do you wish to make a further response or? Recognize the Honorable Minister of Finance.
Madam Speaker, I've made my presentation, and since in the absence of members from the other side, clearly the bill has the full support of the House, and I commend that we go to committee stage after the second reading.
Thank you. So it has been moved on.
But sorry, Madam Speaker. Madam Speaker, if I may just add one other point. I can recall as chairman of the Monetary Council some years back that we had a problem with commercial banks, the indigenous commercial banks, many of whom were going belly up. And the recommendation coming from some of our regional supporting institutions and also the World Bank was to close all domestic financial institutions, to the extent that they did not even care whether or not the poor people of this region lost their money. We were in a position to hold firm. We went to Washington, we spoke with the bankers there. They did not take us on. We went to CDB. CDB sided with the World Bank, but we held firm. And now we have indigenous banks within the region who are holding firm. And with the support of the ECCU and the ECCB, we have been able to resolve all of those issues on our own. And this bill is one which continues to help us to be on stronger and firmer footing together. As we always say, together we can, and together we will.
All those in favor that the bill shortly entitled Eastern Caribbean Deposit Insurance Corporation Agreement Bill 2026 should be read a second time, say aye. And those against, say nay. I think the ayes have it. The ayes have it. The bill will be read a second time.
Eastern Caribbean Deposit Insurance Corporation Agreement Bill 2026.
The Assembly will now go into committee to consider the bill further. I recognize the Honorable Minister of Finance.
Thank you very much, Madam Speaker. Madam Speaker, I wish to inform this Honourable House that a bill shortly entitled Eastern Caribbean Deposit Insurance Corporation Agreement Bill of 2026 has passed to the committee stage of this House with no amendments, and may I therefore propose a third reading of the bill.
Seconder, please. I recognize the Honorable Deputy Premier.
Madam Speaker, if it pleases you, I stand to support the motion for the third reading of the said bill.
It has been moved and seconded that the bill shortly entitled Eastern Caribbean Deposit Insurance Corporation Agreement Bill 2026 should be read a third time and passed. All those in favor say aye. Those against say nay. I think the ayes have it. The ayes have it. The bill will now be read a third time.
Eastern Caribbean Deposit Insurance Corporation Agreement Bill 2026.
The Eastern Caribbean Deposit Insurance Corporation Agreement Bill 2026 has been read a third time and is accordingly passed. I think the next bill is the Police Amendment Bill, which continues to be at the Select Committee. Okay, the Chair. So I was just about to ask you if we remain in the committee stage with that bill.
Thank you, Madam Speaker. Yes, we are. Madam Speaker, we have had some challenges in meeting last month. The police was very busy with St. Patrick's, so we were not able to meet. And on our last meeting, they indicated they could not make it. The committee has looked at another approach, and we will seek to explore that. And if that doesn't work, Madam Speaker, we'll come back to this Honourable House and let the House know, and we determine a way forward. I do not know if the Attorney General wishes to respond at this point, or I can just go on to the other bill, the other committee.
Well, you want to say something on the other committee? There's not right, it's not on the agenda, so.
Before some committees. So I went back up here.
Oh, okay, when we go back to that. Thank you.
Reports from committees.
I recognize the Honorable Deputy Premier.
Thank you, Madam Speaker. Please excuse me for preempting. I wish to say that with respect to the Standing Orders Committee, we are making good progress with reviewing the standing orders, and we will continue to report to this House should we have any difficulties in the work undertaken by the committee. Just to remind members of the House who should have a copy of the bill that we're reviewing. The draft that we're reviewing. We ask that you keep abreast of it so that when we bring the recommendations back to the House, you will be familiar and we can advance this work quickly so that we are not repeating this cycle again. This draft was before a previous government, and we were not able to bring it to a close before that session was completed, and we do not wish for this to be repeated. We see the number of challenges that arise in this House, and so we can note those so that when we draft, the draft is finished, we'll be future-proof and ready to move on with a modern framework under which this House will be continued to operate for the honor and respect of this honorable institution created by the Constitution. We cannot take this lightly, It's a serious institution and therefore should be accorded the respect that is due it. And that type of respect that is engendered will come with the type of framework under which we operate and the knowledge and understanding of members of this Honorable House of the said framework. Thank you, Madam Speaker. If there are no questions for me from this Honorable House, I will take my seat.
Thank you.
Ministerial statements, government notices, unofficial notices, questions, other business, adjournment.
I recognize the Honorable Premier.
Madam Speaker, I rise to move a motion for the adjournment of this Honorable House. Sign and I.
I recognize the Honorable Deputy Premier.
Madam Speaker, I rise to support the adjournment for this Honorable House. Sign and I.
It has been moved and seconded that this Honorable House stands adjourned. Sign and I. All those in favor say aye. Those against say nay. I think the ayes have it. The ayes have it. This Honorable House now stands adjourned. Sign and I.